this week's episode of Your Business with Accent Nominees. I'm Daniel Olukayode Adeyemo. Today we'll be looking at a very important topic, more like a flow from what we've been discussing for a few weeks now. Today we're looking at non-compete agreement. Last week we looked at one of the contracts, though not a contract specifically, but a way to protect consumers. And then previous weeks we've been looking at different contracts, but today we'll be looking at non-compete agreement. And let's face it, when starting out, in business and entrepreneurship in general, one of the things you're trying to look at after getting a place to work is you're trying to pull, great people together that can actually push the vision, the mission of your company or your business. So in the process of bringing people together, for people that are actually qualified to be part of the team, one of the things in trying to achieve the vision and mission is that this is quite incidental to it though. You share confidential information, business strategies and all of those things, marketing strategies here and there. Your trade secrets, it's made known to every team member. Right, so every team member knows about all of these things. So you can't say you want to achieve all of these things and the vision and the mission without sharing all of these things with your team member. Now, but the issue that now comes to play is when that maybe a team member or any team member decides to, what, I think I want to leave and start my own thing. I want to leave and join a different company. All of those things, regardless of whatever happens on the background. Now, one thing we can't deny is the fact that that team member that's leaving already has an awareness of the confidential information, the trade secret, and all of those things of your company, right? So this is where the non-compete agreement comes in to protect the employer, let's say the former employer now in this case, right? So this is the need for non-compete agreement. And one thing we should also state is that this non-compete agreement, what it does basically is to prevent a former employer who is leaving the company from using that confidential information to the detriment of the company. For example, by going out to start, so basically, let me be even practical based on the terms usually stated, is that they don't want the person leaving to go start a business within that same business environment, within that same trade, within that same sector, then within the same area, within a geographical area, depending on what it states. So the whole essence is to protect you as an employer, that person that's actually leaving your company, from actually going to start something that kind of relates to, that's within the same thing of what you do, and then within the same area, or to join a competitor, right? So the whole essence of this is just to protect your trade secret from being used anyhow, right? So that's the general idea about it. We'll be progressing into more detail within the next few minutes. Alright, now, what is a non-compete agreement? But mind you, let's have at mind the fact that a non-compete agreement, we can have a non-compete agreement or a non-compete clause. So it could be an agreement, a full agreement in itself, or it could be a clause in an employment contract or agreement. I hope you get that. So now, speaking to what a non-compete agreement is, so I won't be telling you it is defined as this. So I watched a movie, right? So in the course of preparing for this, I flashed back to a movie I actually watched some time ago, The Family Man. You might have watched it. So what happened there is that this non-compete agreement really came to play. One thing was that the main character in the movie worked for his friend. Now his friend is also his boss. And the kind of work they do is such that if you're a person of moral, you are easily moved by emotions, you won't be able to do it. Because a lot of decisions they make is, like I said, if you're an emotional kind of person that you like to pity people and all of those things, you won't be able to do it. So this guy, despite being his friend, he was one of the top two talents or stars in that company. Right, and back to back, he's been delivering sealing deals and all of those things. So he got to a point where he, for the first time in his career, decided to, take morality over his job. And at that instant, he was sacked by his friend. He has always known his friend to be the kind of person that would want to, even though you've been performing well, right, and then one mistake you make, he sacks you. But he never knew that he could do it to him, being his friend. Right, but that's not even the issue. Now the issue here is that upon being sacked, he presented the non-compete agreement which he signed prior to him, during the course of negotiating his own working with the company. So he presented and let him know that, see, remember the terms of the agreement, you can't go against this, you can't go ahead. And so the implication of this is that this his friend that is leaving cannot go out and say he wants to start something similar to what his boss has been doing, right? Even though they didn't really state for how long, but that was the case. And then he cannot actually go out and he cannot go out and work for a competitor of his boss, of his former boss, right? So although towards the end, he actually, the boss, I don't know, he was moved to emotion. He's normally not like that. He doesn't cancel his non-compete with any employee that leaves. But for him, he decided to cancel it. So what actually happened was that he sent the torn pieces of the non-compete agreement to him. He mailed it to him as a sign that he can as well go ahead with what he wants to do. So I hope with this little story here and there, you've been able to pick the essence of this story, and which is what the essence, the responsibilities attached to a person who agrees to a non-compete agreement, particularly the employee that agrees to it, right? Is that you cannot go and start something similar to what your boss, similar to where you were working before, within a specific area, and you cannot also go and work for a competitor, right? The whole essence of this is just to protect the trade secret of that company. So now let's move down to the law. Now, going by all of the stories I've shared with you, two things stand out, and that's the fact that in terms of restriction, that is restriction of the employee. First of all, the employee is restricted from doing those two things we spoke about earlier within the course of the employment, and that is quite ordinary because, of course, you're working with someone, you want to go and start something similar, you are loyal, you are like dedicated to that place where you work. Then now the second restriction is after your employment with that company has been terminated, which is ordinarily acceptable, it's quite normal because, of course, when you're leaving, it's either you're trying to get a job or you're starting something for yourself. So it is normal. So, but then the issue here is that remember last week we spoke about, I mentioned a law, a principal act guiding consumer protection, which is what the Federal Competition and Consumer Protection Act of 2019, right? So this act, prior to this act, the law, basically there have been issues in court of, oh, this employer is saying that this person should not do this, he worked with me, he's trying to take our confidential information out. So prior to this act, the law, the courts, they would usually look at the reasonability of that contract, right? So they will usually look at the reasonability. How reasonable is it, right? So in determining the reasonability, they will look at the nature of the business, that is where the person worked before, or the nature of the business that they're actually considering at the moment. They will look at the geographical area which the restraint is to be imposed, the geographical area, the nature of the business, the geographical area, as well as the given period for which it is to continue. So in those times, prior to this act, those times the court will look at, 4 years. There was actually a case where within 4 years they're like, okay, it's cool. It's not too bad. You can, within 4 years, you can restrict him from doing those two things, right? Any of those two things. Then after 4 years, he can go ahead and start his company, even though it's the same thing, similar to the same industry, similar to what you're doing, right? So within 4 years, you can. So some of those cases is just reasonability, basically. 4 years seemed fair to the courts in some instances, 3 years, 2 years, depending, right? But when this act was actually enacted in 2019, January 2019, when this act was enacted, the old reasonable test was pushed aside. So what came to play was the 2-year rule. So what the act stated was this, that regardless of how reasonable the contract is, provided that the two of you agreed voluntarily and there's no duress, right? That is one. And also provided that the limitation does not exceed 2 years, it is okay. Meaning the contract is fine. So there's no issue as to reasonableness whatsoever. The 2-year rule is the main focus of this act, the federal or the FCCPA, right? So let's pay attention to that. And let's look at the legal implication of a non-compete clause. So now, from what the stories we've been saying, this is what we're trying to look at now. It's more or less like a derivative of what we've been looking at, what we've been talking about for the past few minutes. One is the employee is prohibited from working with a competitor upon the termination of the given employment for a period of 2 years. We already emphasized that before. So you are prohibited from working with a competitor, or or starting something similar to that thing within a period of 2 years. Another is the employee is prohibited from disclosing the employer's trade secrets, business strategies, marketing and confidential information gained in the course of the employment. You can't disclose that. So another implication is that the employee is prohibited from enticing his former employer's client for his new employer or business, or former co-employee of the former employer. So what this one is saying is that you can't bring in someone that worked with your employer to your own business. There will usually be an issue of conflict of interest and all of those things. So these are like the three implications of the non-compete agreement when you decide to sign a non-compete agreement. Alright, so now earlier we spoke about the issue of there being contention in court and all of those things. So usually there are remedies available to you as an employer of labor, where a person leaves and then the person breaches the non-compete agreement or clause. So you as an employer, you have the right to ask. Mind you, if you don't ask for some of these remedies, it won't be granted to you. You need to ask. When you ask, you receive, depending on the circumstance. So you may ask and not be given, So, but then you need to even ask first of all, and of course with the aid of your lawyer, assessing the circumstance in the case and the fact, it will determine how appropriate a remedy you're asking for would be. So one of the remedies you can ask for is damages, right? So damages, and mind you, damages is not damage. There's damages, there's damage. Damage is what you've done wrong, right? Which is what the breaching, damage is mainly breaching, in this scenario what we're talking about, breaching the non-compete agreement. Then damages is what more or less like a compensation given to you as an employer who has been damaged, quote unquote, in terms of course the non-compete agreement. So damages now can be in three forms. It can be compensatory, it can be punitive, and then it can also be liquidated. So for compensatory, what this one is just trying to do is trying to bring you back to a position you were, provided what happened, provided that employee, that whatever the employee did to you, maybe did with your trade secret and all of those things, it's that this damages brings you back to a situation where you feel like nothing has happened. I'm trying to make this sound proper. So it returns you to a place where you don't feel like anything that ever happened before. For example, you lost certain things. When you ask for these damages, it brings you to a place where you are adequately compensated, such that it doesn't feel like anything happened. It's like someone took money from you and then the money was returned back to you. You are back at the place you were before, where prior to when the employee did anything wrong to you by messing with the trade secrets, confidential information, and all of those things. So basically, you can ask for compensatory damages. It can be given to you, based on the fact of the case. So another one is punitive damages. So this one, it comes to play where in the course of the case it is seen with adequate evidence that malice is involved in the case at hand, right? So where it is proven that the employee that actually left your company was malicious, I was like, I'm going to show this guy. It will be seen. The facts are so clear that this employee, he has said, I know all these trade secrets I had access to while working with you. I'm going to exploit them to detriment of you, Oga. I'm going to use it to your own detriment. I don't care what happens. So once the court can dictate this in the course of the case, then you will be awarded punitive damages, which could be way gross, depending on the situation at hand. So another is liquidated damages. Now, liquidated damages basically is, when you have a contract, the non-compete agreement or clause, where it says that, where you breach this agreement, you will pay so amount. So that amount you've agreed in the contract is the liquidated damages. Do you understand? I hope you understand. So another remedy is injunction. So this one is for where you're seeking the court that, court, please order this employee to refrain from this thing he's doing. Probably the employee, by virtue of messing with the confidential agreement and all of those things, he has caused so much damage to your business. and you're telling the company that the court that, you know, yes, we're also seeking for damages, but also tell this person to stop this thing he's doing. Tell him to refrain from doing what he's doing currently, because it is negatively impacting your company. So that is where injunction comes in, right? So these are two of some of the remedies you can ask for. So now, bringing everything together, there's need to be a balance, because in all of this, there's the interest of the employer, there's the interest of the employee. So in the course of drafting your agreement, drafting the clause, we need to be sure that, you know, both parties are adequately catered for. So this is why you need a lawyer. This is why you need a well-experienced lawyer in all of this. So don't go ahead and just sign stuff as an employee. You can reach out to a lawyer to help you review the agreement. Is it fair? Is it okay? Does it align with the law and all of those things, right? And for the employer as well, it's very important for you to be as fair as possible to your employee. This will be all for this afternoon. I hope you've been able to take something from this. So this is a real life thing, to be very honest. You know, when starting out in your entrepreneurship journey, business journey, you're bringing people on board. It's very important for you to have this contract in place. But in having it in place, don't make it such that it is unconscionable, in such a way that it's, you know, it's puts the other party at a huge disadvantage, right? Be fair to. I know I understand as a business person, you're trying to, as a business owner, as an employer of labor, you're trying to protect your interests. But then that should also not be at the detriment of your employee or potential employee. I hope you've been able to pick one or two things from this session today. Thank you for being a part of this session. I hope you find it helpful. And mind you, we also have recorded previous sessions in the past, and you should as well go through it. It will really help your business. And if you know someone that should actually see this video, that should actually see this discussion, kindly share with the person. You know, at the end of the day, it's for free, and that's the thing. It's for free. You get all of this information for free, and I hope you do have a great day. Thank you so much for your time. Thank you for being here. Do have a great